Good day and welcome to Epstein Becker Green's webinar, Wage and Hour Issues in Post-Acute Care. We are pleased to have two fantastic speakers today, Epstein Becker Green's Adam Abrahms, who is a member of the Labor and Employment and Healthcare and Life Sciences practices, and Aaron Olsen, a member of Epstein Becker Green's Labor and Employment practice. Before we begin today's presentation, please be informed that today's webinar is being recorded and the participant phone lines will be placed on mute throughout the program. You are welcome to submit questions throughout the program by using the Q&A feature provided by WebEx, and at the end of the program, with time permitting, the speaker will address your questions. You are also welcome to submit questions directly to the presenter following the webinar. Contact information will be displayed at the end of the presentation. And approximately 2 to 3 business days following the webinar, Epstein Becker Green will communicate the availability of the webinar recording and access to the PowerPoint materials. At this time, I'd like to turn the webinar over to Adam Abrahms.
Good afternoon for those of you on the East Coast, and good morning to the rest of us. This is Adam Abrahms. I am a partner here in the Los Angeles office and in the employment department with a focus on my practice on healthcare. And I'll be joined today by Aaron Olsen, who's also in our Los Angeles office. We have an exciting program for you today. We're going to focus on some of the hot topics in the areas where we're seeing more and more post-acute care facilities and other healthcare institutions find themselves in some wage and hour predicaments. We'll talk specifically about the Fair Labor Standards Act, drilling down into some meal break issues, off-the-clock work issues, travel time, some alternative work weeks and other flexible scheduling options that are available for healthcare employers. Then we'll talk about some exempt and non-exempt issues, as well as regular rate calculations. And finally, to make everybody feel a little bit better that doesn't live in California, we will spend some time talking about the behavioral health unit of wage and hour law, which is known as California. So with that, I'm going to turn it over to Aaron to address some of the Fair Labor Standards Act issues.
Just as an initial point here, it's important to recognize that we're having much more focus on the FLSA at all levels. Not only are we seeing more plaintiff side work, more class actions, but also with the government. This was something that recently President Obama came out and said that he was going to ask for more focus to be placed upon this. And as well as we can see here, the Department of Labor Secretary has explained how he believes that this is a critical area that they're focusing on. We're seeing more funding to go towards enforcement initiatives. We're seeing larger cases. We're seeing more cases. In fact, we're at a record pace on the number of cases that we have brought under the FLSA. As we indicate here, there's an increase in claims by over 50%. One of the things that I think would keep many people up at night when you have to deal with the FLSA are the private class actions, because what we find here is there will be what appears to be a small issue, and typically these will be issues that you weren't even aware was an issue because nobody was complaining about it until you have a disgruntled former employee who goes to a plaintiff's attorney, and what they were complaining about ends up not being the issue that they bring a lawsuit about. Instead, what they find is somewhere in your policies and practices some problem, and we see private class actions. We've seen an increase of 70% of wage and hour suits over the past decade, and we had over 7,700 new cases filed under the FLSA last year. When we look at the most common claims, overtime and off-the-clock claims are the most common. However, and we'll get into more detail as we go to the threat areas, the missed meal breaks and donning and doffing claims are something that we need to be particularly sensitive to in this industry. So I'll turn it back to Adam, who's going to talk about some of the potential threat areas.
All right. Well, you know, many of you will probably have dealt with some of these issues in the past. We will focus on a couple that we're seeing an increased rise on, as Aaron indicated, where we are, you know, we're really seeing things come out in terms of there really is no free lunch when it comes to trying to to be a good employer in the healthcare industry.
And let me start here with the potential threat area of the meal breaks. So under the FLSA, there's actually no requirement that the employer provide a meal period. However, where this will come up is with the state law or your own policies and practices. So it's very common, even if it's not required by state law, for employer to have a policy where you provide a 30-minute off-duty meal period. And if that's the case, then we need to be certain that they're complying with the policy. So if it's a meal period that's less than 30 minutes, generally that must be paid. If it's a meal period of more than 30 minutes, then it doesn't need to be paid so long as no work is performed. And this is an area where people get tripped up in, because the employee must be completely relieved of all duties during the meal break to deduct this time from their paycheck. So the best practice here is to when we look at some of these potential threat areas, one of the issues that you will run into is that, again, this won't come in the form typically of a single plaintiff bringing a claim. Typically, these will come as a class action. We're seeing very large class actions where damages are in the tens of millions of dollars, because if there's just one problem with the policy and that problem pervades every single employee for every single day, then what you're going to have is a class action, a lawsuit on your hands. So in terms of the best practices, we would encourage everybody to, in order to minimize the risks of unlawful meal period deductions, is to make sure to record people taking their meal periods, when they take them, and to audit that periodically to ensure that indeed they are being relieved of all duties. If you're finding that people like to continue to work during their meal period and they say, oh, I'm just doing that for just to catch up, they may bring a claim later saying that that they were not relieved of all work. As part of the time card process, employers can ask employees to certify whether they received an uninterrupted 30-minute consecutive meal period. So that's something that you can have on your time cards, as well as provide a reporting mechanism for missed and interrupted meal periods. So if that's important to have, where if someone is denied a meal period, for instance, they get too busy and they're not able to take their meal period, if you have a mechanism in place in which they can report that, hey, no, I did have to work through that meal period, so they get additional pay for that, then that is a helpful defense. In some cases, meal period waivers may be appropriate. We'll get into this in more detail, where this can be a problematic area to determine whether or not people truly can rely on the meal period waiver. You can also consider requiring non-exempt employees to clock out for meal periods and then clock in at the conclusion of the break to establish a clear record of the meal period. With respect to automated systems, we believe it's advisable for the employer to have a policy and procedure that, with forms that allow the employees to override automatic deduction. So if you have a process where you automatically deduct a 30-minute meal period, there needs to be a process in place should they not be provided a meal period on that particular day.
and let me just add to that I think that this is with timekeeping systems and HRIS systems and all the different types of systems that the technology that becomes available, in many ways it makes administering our employees easier, but it also presents a whole lot of areas for potential threats, and this is a big one when you're automatically assuming somebody takes a break. They don't say anything. You don't have a mechanism for them to guarantee that they did take it, and then lo and behold, some years later they come back and say, well, I routinely didn't take a meal period, and it becomes a he said, she said sort of dispute. And then it becomes worse when they say, well, not only did I not take it, everybody I worked with didn't take it, and then you're facing one of these class actions. Similar to that is off-the-clock work. This is an increasingly large problem for a lot of employers. In fact, I had a healthcare employer call me yesterday with an issue where we had to go back and forth because they didn't want to pay a particular employee who had called in sick, said, I'm unable to come to work today because I don't feel well. And in the middle of the day, on their own, without being asked to do so, they picked up the phone a couple of times and they called into their supervisor because they felt like the supervisor needed to know certain things about the patient that particular employee was taking care of, or at least that particular employee knew about some issues that employee or that patient was having. Of course, all of these things were in the charts, and there was really no reason for this employee to call in. But then the employee said, I want to be paid for the time I spent calling in. And we had to have the discussion, well, in fact, you need to pay that employee because that employee was working. They were suffered and permitted to work, which is the standard. And if an employee performs any compensable activities, they need to be paid for that time. Most common, this comes in the form of pre-shift or post-shift work. Maybe huddle meetings sometimes. We'd like you here at 7:15, but your shift doesn't start until 7:30. But we want to make sure we can give you a pre-huddle meeting, or after the day is over at 7 o'clock in the evening, maybe you're supposed to clock out, and you tell people we don't authorize. You need to have overtime authorized, and there becomes a whole concern about that. And so what happens is employees then they clock out and then they finish their charts, or they finish their paperwork, or they finish giving report, and those sorts of things can be very large issues that need to be dealt with. Similarly, donning and doffing is a big issue throughout the country with when you're having employees change clothes and put on protective equipment and do other sorts of things. You really need to look at the nature of what is going on, whether this is being done voluntarily. For example, are you permitting them to, say an employee has to wear scrubs? Can they put the scrubs on at home and bring them in? But you provide an option for them to keep it in a locker, and they can do it there too. If you get into, increasingly with infection control mechanisms and sanitation issues, we are finding that there's other types of protective equipment or clothing or other sorts of things that some of our healthcare clients are asking employees to put on. And this is really a fact-based analysis that you really just need to be cognizant of. If an employee is being asked to put something on or needs to take something off before or after work, we need to look at it and focus on whether or not that's compensable time and dealing with it. Training. Most training is going to be compensable, and it needs to be paid. And unless the training meets all four of these listed criteria here, it's voluntary. The employee's doing it on their own. They don't need to. They're not being required to do it. It's not. Even if it's not quote formally required, the supervisor hasn't made them feel as if it is de facto required. It is truly voluntary. It is not job-related. Well, that just seems ridiculous, right? What does that mean? It's not job-related. Why would we be offering the training? But in essence, it's really, is this something that's advancing the skills or taking to the employee to the next level, or maybe creating promotional opportunities for the employee? And it is not a part and parcel of their current duties and kind of a minimum expectation level of training. It is done outside normal hours of work, right? You can't be having them do it during their normally scheduled day and then say this is training and we're not going to pay you for it. And that there's no other work that is concurrently being performed. So even if it does meet those other three criteria, if it's maybe some kind of advancement class or training that is helping an employee be prepared to advance to the next level of within their career, but you're having them perform substantive work that benefits you. They're performing some actual patient care duties. It's not just classroom training. It's more clinical training. Then you have issues there as well. So it needs to meet all four of those elements. Increasingly in our technological age, this last category here is a huge problem. As I mentioned before, we have these advanced HRIS systems and other types of technology, remote access systems, many things that benefit your facilities and help you be more efficient, and actually in many ways help employees. Sometimes we allow employees to have some remote access for scheduling or to do other sorts of things. That's actually okay. That's not work. But if they get remote access to do other sorts of things, if they can do charting or email or anything like that, that is considered to be work, or that is, lending towards patient care or within that category of some sort, then certainly that needs to be compensated. And unless it's truly de minimis, it's a couple of minutes, maybe not, but anything beyond that, even in the aggregate, then it needs to be compensated, including checking emails. You want to be, if you're giving a non-exempt employee access to email, whether it is in the form of a smartphone or in the form of a remote login, then you need to be very cognizant that when they're checking their email, not necessarily even writing or responding to substantive email, but if we've seen cases where the employee says, well, I was given remote access and I was led to believe that I should be checking it, so every night I would go home and I'd spend 15, 20 minutes reading the emails that I had received on my day off or after work, and that would be compensable time. So you got to be very careful with providing any type of offset site access. Communication with their supervisors, right? Oftentimes supervisors may call somebody when their schedules are a little different, certainly in the healthcare industry where you have folks who don't have a 9-to-5 job often, and the supervisors will call and have substantive discussions with an employee while at home. That certainly is compensable time, and we see a lot of claims like that. You also have supervisors who in the industry, a lot of supervision in the industry is hourly. And if you have hourly supervisors who are performing their supervisory duties, they're going home, they're performing their performance reviews, they're doing other types of things outside of work, that is problematic. And as I started this discussion with, work-related phone calls, they don't even have to have a supervisor involved, right? You need to sometimes put some controls on how employees communicate with each other, right? The night shift nurse wants to call the day shift nurse to ask some questions about some of the patients or the medication or the charting or something to that effect, and those types of areas can get you in trouble. And again, this last one is one that's fairly fact specific, and if you're doing these things, you probably want to check into it, but requiring people to go in for some sort of testing, recertification testing, those sorts of things is oftentimes compensable. Moving on, we'll talk a little bit about travel time. Obviously, folks that are any kind of travel that is part of their principal activity is compensable. This comes up a lot with employee classifications that may go from home to home, or maybe from clinic to clinic within the day, or for whatever reason. I have a client that has two facilities 4 miles from each other, and people tend to, go back and forth, and depending on when that is taking place, that is compensable travel time, and there also is potentially an issue depending on where you are, whether you need to reimburse them for the expenses. But for the most part, you need to look at where their quote home base is and determine whether when the start of their day is based on their home base, and any time in between needs to be compensated. Certainly, if you're sending them to either training or other types of things that would be outside the norm, and they may require somebody to leave a little bit early to get there, or outside their normal day, then that's going to be compensable, and then there's a whole host of rules associated with if you're sending them on overnight travel that you need to be cognizant of. The other issues that come up a lot is in the healthcare industry. We have some options available to us. I'll say this right now, outside of California, that you can take advantage of. Most folks in the healthcare industry, while 880s were designed for hospitals, they are applicable to many other healthcare institutions, including most post-acute care facilities, where and an 880 is an established overtime system that really looks at a 14-day pay period. So instead of using your traditional 7-day pay period under the FLSA, an 880 permits you to use a 14-day pay period and allow employees to kind of push their days. Oftentimes employees will want to work 12-hour shifts, and they'll want to work really 4 or 5 of them in a row, and so when you're able to use those 880s, that can be helpful. With respect to if you're going to do that, one, you want to make sure you understand the rules, make sure your particular institution is one that would be considered a healthcare institution that would where this would be applicable, and then you need to have an advance agreement with either the employees or the union involved, if there's a union involved, to do that. There are other types of alternative work weeks, flexible work week schedules, flex time schedules, pay equalization plans. These typically will require an agreement with the employee and will fix overtime. There are things that can be fairly factual specific and probably go beyond us going too far in depth today, but it's important for you guys to know that they're available and sometimes to think about them if you're running into unpredictable overtime costs and you need to try to maybe balance that out a little bit. That is often helpful. And I will turn it back over to Aaron to talk about exempt and non-exempt classifications.
So one of the common questions that we have is whether or not an employee can be classified as exempt or non-exempt, meaning that they would be exempt from the overtime requirements. And so here is a little bit of a checklist that you can go through to determine whether or not your employee meets the professional employee exemption. Usually there's not an issue here with respect to the amount that they're paid. It's relatively small, $4.55 a week. The work would have to require advanced knowledge, such as in a field of science. Another is the academic training, whether that's a prerequisite to enter into the field, for instance, if you have licensing requirements. There are specific recognized professionals that meet the exempt classification status, such as registered or certified medical technicians that require a degree, registered nurses, physician's assistants, dental hygienists. There's also those that it's been determined generally are not recognized as professionals, including licensed practical nurses and technologists where a 4-year degree is not required. Of course, medical doctors, they're completely exempt. Now, one thing I should say, having gone through all of this, is if you're in California, you should just ignore everything that I just said, because that does not apply to California. Next, when we should look into some of the issues regarding the regular rate. This, again, is one of these issues that is in the minutia, where it may be something that you're not aware of, but when you have your disgruntled former employee goes to the plaintiff's attorney, I can guarantee this is something that they will look at because it's an easy class action. So the issue is if you have non-discretionary bonuses, for instance, something that is like a performance incentive, that has to be included in the employee's regular rate of pay to determine the overtime payment obligation. So what that would mean is if you pay an employee $10 an hour and that employee can receive bonuses, and we'll go through some of these other points, those bonuses have to be calculated and incorporated into the regular rate of pay for when you determine what the proper rate of overtime is. So again, it gets down into the minutia. It's something probably your payroll people would be dealing with, but this is an area where we see class actions if something is off. So on that point, in addition to the non-discretionary bonuses, if you're paying extra compensation for instance, working a holiday or weekend shift or coming in on a day off, there's some sort of differential that gets paid. You don't have to incorporate that additional payment so long as it is at least time and a half of the regular hourly rate. So if you say, if you come in and work on Christmas, we pay you double time, you don't have to include that time or that additional payment into the regular rate. But if you pay, for instance, an extra $1 an hour if you come in during the weekend or if you work a night shift or something like that, that's not going to be 1.5 times their rate of pay. That differential has to be included in the regular rate. If you pay for on-call time, whether it be controlled or uncontrolled, that time would have to be included when calculating the regular rate, as well as callback minimum guarantees. We also see a fair amount of differentials for longevity differentials or shift differentials. For instance, if someone is working as a trainer or has taken on additional responsibilities for a shift and you pay them a couple of extra dollars an hour, that has to be included in the regular rate of pay when calculating overtime.
And before we move on to California, let me just add on that, and I may sound like a broken record, and I don't have anything against HRIS systems. I think they're obviously necessary, and they're making 99% of the time they're making things easier. But you need to check. Too often we've encountered clients who come to us and said, hey, we have some kind of wage hour issue. They're claiming there's a regular rate issue or something to that effect, and we just presumed that we spent X fill in the blank giant number of dollars on our HRIS system from a nationally recognized HRIS system provider or a payroll provider or something, and we assumed that they knew how to calculate all of these things and that they were doing it correctly. And sometimes your agreements with them may provide some indemnification, but they don't provide indemnification from heartache. And so you want to be sure that all this minutia, as Aaron was referred to it, is being addressed, and that you've thought about it, and that you've asked the questions of whomever it is that you've made responsible for ensuring that these regular rate issues are being taken care of. So for now, before we get into questions, we definitely want to make sure we had some time for questions. We see some lined up already. We wanted to make sure that for all those in California who we keep telling forget what we say, that you have some information, and for all of those outside of California, this is an opportunity for you to feel a little bit better about the issues that you're dealing with, because they could be a lot worse. As we said earlier, we sometimes refer to California as the BHU of states when it comes to wage and hour law, and there is a lot of issues that are very drastically different in California, including overtime and alternative work week, basically everything we just talked about, the meal and rest periods, pay requirements, and a host of other things that are very, very different in California. We want to highlight a couple of them. The first one is daily overtime. I think most folks recognize that California is kind of an outlier in this area. We require overtime for all work over 8 hours in a day. It has to be time and a half, that regular rate of pay that we were just talking about. And that is time and a half, not just over 8 hours, but only from between 8 and 12 hours. Once you get over 12 hours, then you have to pay double time. You also receive, like the FLSA, and this isn't listed on here, but if you work over 40 hours a week, not only are you entitled to overtime under the FLSA, but California law would also require overtime over 40 hours in a week. Even if, and this comes up not that often, but occasionally some folks will work, 5 hours a day or 4 hours a day. They come in, they do some specialized assignment. If you make those people work 7 consecutive days, regardless of within one work week, as established in your payroll system, even if they haven't gotten to 40 hours a week, that 7th day is an overtime day, and it's time and a half for the first 8 hours. And if they get over 8 hours, it is double time. Of course, the minor solace that you get is that there is no pyramiding of overtime. So if an employee works overtime over 8 hours in one day, say they work 10 hours, that those extra 2 hours that you've paid at overtime don't go into the calculation of determining whether or not they get over 40. So that is some minor solace. California, though, does have some opportunities to work around that. The California alternative work weeks are drastically different than those in other states, but they do provide for healthcare industry employers an opportunity to have employees work up to 12 hours in a day without overtime, 40 hours in a week, no more than 40 hours a week. There has to be an established alternative schedule with identifiable work units. That could be anything from, we want to do it for the entire facility. We just want to do it for our weekend folks. We just want to do it for this particular classification. Maybe our RNs are going to be the only ones that we classify. And yes, I just said RNs because RNs cannot be exempt in California. So you got to figure out which work group, and you can either do it for the entire group or for identifiable segments. But then you have to go through a very, very strict process. And before I go into what that process looks like, I want to point out that you can't combine an 880 format with a California AWS. You kind of need to pick one or the other. So if you're used to using an 880 and you want to use that 2-week format and allow people to kind of bunch up their days in a way that is kind of focused on 1 week, then that would you couldn't also use the California AWS. You got to pick and choose. And if you want to choose that AWS in California, there is a very, very complicated system. We actually I've done an hour-long training just on this for folks, but this is a quick summary of it. It starts with a proposed written agreement that establishes the schedule, something like, we're going to have you work 3 12-hour shifts a week, and you're not going to get overtime up until after 12 hours. You have to provide that the proposed written agreement. You have to give an employee a kind of a memorandum that describes all of the way this would work, and then you need to permit a secret ballot election. and then you have to report the results to the state for the state to keep on, hold on to and have a record of. Or, as it says here at the bottom, this is one of the very few times that it might be beneficial for you to have a union. You can go to your union and you can get an agreement that you're just going to do this with your union in California. And if the union agrees, your employees don't have to agree. And you don't have to go through this process. But, of course, you do have to deal with the union. I'll turn this over to Aaron for the rest of the substance before we get to the questions.
So with respect to the California meal and rest periods, again, this is different than under the FLSA. In California, an employee cannot work more than 5 hours without a meal period of at least 30 minutes, unless the employee works no more than 6 hours, in which case the meal period may be waived by mutual consent, or unless the employee works no more than 12 hours, in which case the second meal period can be waived by mutual consent. So here's the issue that a lot of healthcare employers run into is it's very common to have 12-hour shifts. And so if you figure, all right, what we're going to do is we're going to provide one 30-minute unpaid off-duty meal period, and then they'll waive the second meal period. But they end up working slightly more than 12 hours, then that waiver of the second meal period is no longer valid. And so what we'll see is, again, a class action where they go through everybody's time records and find, oh, this person worked 12 hours and 15 minutes, and this person worked 12 hours and 10 minutes, and, oh, boy, they weren't provided a second meal period, so there should be a meal period penalty for each of those instances. So that is something to be very careful about and watch. In California, the employers must make the meal periods available, but they don't need to ensure that they are taken. That said, this can vary by industry. You have to be careful to make sure that you are not putting pressure on people to work through meal periods. Again, that's off-duty time. They should not be doing any work so that they, because it's not compensable. Now, there are occasions in which you can have on-duty meal periods, but this is narrow, where it has to be the nature of the work would prevent the employee from being relieved of all work. The employee has to agree in writing in an agreement that states that it can be revoked at any time, and you can only have one on-duty meal period taken during a day. So again, you can run into an issue where if you are waiving a meal period, let me take that back, if you are having an on-duty meal period, so it's still a meal period, it's just on duty, and then you say, well, we're going to have a 12-hour shift and we'll waive that second meal period, but they go beyond the 12 hours, again, you can run into a problem. Employees are entitled to a 10-minute rest break for each 4 hours worked or major fraction thereof, meaning if they work, for instance, 6 hours, then they should be having 2 rest breaks during that time. And again, those are paid rest breaks. There are, again, specific requirements in California that have to do, start with the voluntary resignation versus involuntary termination. If an employee quits, you have 72 hours to get that employee their final paycheck. If you terminate an employee, you have to make sure that on their last date of employment they are provided with all wages due. So that sometimes can create a procedural headache where you terminate somebody and you need to make sure the processes are in place that that employee is getting paid everything they're due on that exit interview as they're leaving. And then finally here, with respect to the detailed wage statement requirements, I won't get into all of the details here. Again, we're into the minutia. But this is something where, again, it's important to look at what exactly is happening. I'll just give you an example of sort of the pitfalls that you can run into. In California, you're required to list the total amount of hours worked. So we've had class actions where you list the total number of regular hours worked, the total number of overtime hours worked, but you don't have the total number of hours worked. The plaintiffs come in and say, you didn't comply with the requirements, you don't have the total hours worked, therefore we bring a class action. Similar issue with one we dealt with where you have to show their rate of pay. The employer showed the total amount paid, the total amount of hours worked. You could do some basic division and figure out what your rate of pay is, but they bring a class action saying, no, you have to show the rate of pay. So these are the sort of issues where, again, it's important to look at what you're doing with your payroll to make sure that it is indeed being done correctly. We can get into just a couple of miscellaneous issues. Important thing to just recognize is that in California, the travel time rules are different so if you have rules that are based off of the FLSA, looking at federal law, you've got to look at this in California because it's going to be different. One of the key differences is that California requires that employees be paid for all time, except sleep time and time spent doing personal pursuits away from home on overnight travel, even if the time does not coincide with the employee's normal work hours. Also in California, we now are at $9 for minimum wage, and that'll go up to $10 for minimum wage, and that will impact whether or not people are exempt, as that's one of the factors in the exemption analysis. So with that, we have some questions right now we can go through.
Yeah, and we have some queued up. We'll start to go through them. If we don't, for some reason, get to everybody's questions, we'll make sure that one of us, either Aaron or myself, will get back to you via email or some other way to answer your question. So please ask away, and we'll get to them. The first question that we have here is we provide our admitting clerks with uniforms that are part of that are dress pants, shirt, and vests. They should have no problem dressing at home in these clothes and traveling, but one employee is often tardy. He changes at work and says we have to pay him for this time. The answer to that question, the answer to that is you don't. If this is something the employee is voluntarily choosing to do, and there's not a reason for it, then you certainly would not have to pay for that time. With uniforms, the way that these are described, though, I will point out that you may have some, especially in California, you may have an opportunity to provide the employee with an expense reimbursement for the cost of laundering them if they're not something that can be fluff and fold, so to speak, thrown in the regular washing machine. The next question that we have is within a single episode of patient care, employee must provide care and document the same. If the employee postpones documentation until later, rather than completing it during the episode, is that later time documenting compensable? That is actually a very common question, and I think that it goes actually beyond just this particular instance and the advice that we would give. That specifically, you need to find a way to, and this is sometimes counterintuitive, but to separate the way you treat employees from a wage and hour perspective from the way you treat employees from a performance expectations or even discipline perspective. If the employee does the work, and it doesn't really matter whether they did it in a way that violated your policies most of the time, you will need to pay them for it. You can discipline, in this instance, you could discipline this employee and say, is it the expectation that you would document simultaneously or immediately after the care that is provided? But if they're doing it after their shift or at some other time you need to care for them. Same thing with meals and rest periods. Where meals and rest periods are required, or where you have an issue similar to that, and the employee is not is not taking the meal period, even though you've told them to take the meal period. This could be a factual situation. It's going to depend on the jurisdiction you're in, but you'd likely have to pay that, but you could discipline them. Clock-in issues, I know, were a big issue. Right, the employee forgets to scan in or forgets to clock out, and we just assume that we are going to clock them out at their stop time. But then they come back and say, well, I worked until 7, I worked 20 minutes or 30 minutes extra that day. You'd have to pay them. You could terminate them or discipline them appropriately for that, but certainly it needs to be paid.
So now, another question that we have here is, it says, our night shift engineer is the only one on duty, so we have him sign an on-duty meal period agreement, and he doesn't get a meal period. Do we still have to pay the California missed meal period penalty of 1 hour pay? So first off, let's assume that the employee, this meal period agreement, that it's in writing and it states that the agreement may be revoked at any time. And he only has one on-duty meal period taken in a day, because those are the two requirements. Then the question is whether or not the nature of the work prevents the employee from being relieved of all work. And one thing to consider there is, so what would happen if he did take a meal period? If he's really the only person there, you've got nobody to cover for him, then you've got a good argument that indeed the nature of the work is such that he cannot take an off-duty meal period, because if he did, you got nobody there. So not to say that you wouldn't have somebody still challenging that. You can never prevent somebody from challenging, but you've got a good argument there that the nature of the work is such.
The next one asks, states that they're a hospital, and can our admitting clerks be on an 880 system, or is it just for patient care physicians? It covers the employer's institution, so it's not by classification, it's by institution. And so if your institution is covered, a hospital would be, you could use an 880 system. It's whether or not you're a healthcare employer.
Then we have another question here that says, is there a requirement requiring extra payment for work on such holidays as July 4th, Easter, Thanksgiving, Christmas in California? The answer to that is no, there is not a requirement. Again, that would just be whether or not you have your own policies with respect to that, but there's no California legal requirement to do so.
I will say, though, anytime you can create legal problems for yourself by being a generous employer. It's the old adage of no good deed goes unpunished. If you are creating a policy that says you get double time on holidays, or we provide an hour paid lunch, and or whatever your policy is that maybe goes above and beyond, and most healthcare employers in this market are doing things that certainly go above and beyond the requirements of the law, and then you don't meet those requirements, then you end up with other wage and hour issues. And certainly if in that instance, if you were to tell an employee we're going to give you time and a half or double time on certain holidays, and then you were to not pay it, you could run into issues for not paying it. The one other question that we have asks us whether we can just go through and tell you, those of you in California, the things that you don't need to worry about. Let me just say from California is, from a kind of a general perspective, California is more stringent. Most states, well, not most, many states are more stringent than the FLSA. California is dramatically more stringent than the FLSA. All employers need to comply with the Fair Labor Standards Act, and the only time you don't have to worry about the Fair Labor Standards Act is when California is requiring something more stringent, or your state, or in some instances your city, right? We're seeing more and more municipalities get involved in this space, whether it be requiring paid sick time or requiring other special minimum wages, other areas. So you need to obviously be cognizant of wherever you are what the local requirements are, and then realize that those requirements only apply if they're more stringent than the Fair Labor Standards Act in California. That would certainly be anything related to meals and rest periods is its own little world here in California. As Aaron mentioned, the travel time is definitely different. So the discussion that I had related to travel time would not be applicable. And of course, when it comes to your exempt classifications, California has a very, very different standard than under federal law. And it is a much more difficult standard to meet. Not only is the minimum salary much higher, but but the requirements of the duties tests on what the employee must do is much more stringent. And then we have a quantitative analysis in California that requires you to perform duties for more than 50% of your time that would be considered exempt. So if and we see a lot of this, especially with systems as they're expanding into California, having classifications that, these people are, why are they exempt? Well, they've always been exempt, and we have, 30 facilities in 12 states, and now we've come into California and we got a class action. That can't be right. But California, you need a special, you need to look at California differently when it comes to exemptions, and also when it comes to your alternative work weeks. We have another question here.
The next question is, if a nurse or scheduler has the phone on weekends but takes no calls or few, can we only pay for the time that she logs that she worked on the weekend when taking the actual call instead of the flat rate per hour? Let's see.
Yeah, the flat rate per hour, or pay, or how does that affect the regular rate? Let me say that this is the concept of controlled standby versus uncontrolled standby. We referenced it. It is a very factually specific inquiry where you have to look at how restricted you are, the nurse or schedule or any employee is, if you have them on on-call time. If the employee is on uncontrolled standby, which generally means, for the most part, the employee is free to engage in their own pursuits, and they're free to do whatever they would like, unless and until they're called, and even then there's not a you must be able to get back to the facility within 20 minutes or something to that effect. Then it's going to be considered uncontrolled standby. And if it's uncontrolled standby, you don't have to pay them at all until and unless they're actually called. Many healthcare employers, again, are being more generous than they need to be, and they have people who are uncontrolled, more generous than they need to be under the law, maybe not more generous than they need to be under the market, but they have employees working in areas where they're on uncontrolled standby, and they pay them. That time is not considered time for hours worked. It's time for it's really just additional compensation, and so the rate can be different, and it can actually be below the minimum wage because you don't have an obligation to pay them at all. But the fact that it is paid at all makes it go into the regular rate. If an employee is on controlled standby and the expectation of the employee is, well, actually, let me back up again. In the uncontrolled standby area, when the employee gets a phone call, you need to pay the employee at least minimum wage for that time that they're engaged in that activity. And that does need to be considered hours worked. It does need to be recorded, and you do need to understand the time aspects of it. In controlled standby, you are in a situation where the person is being restricted in their daily activities to the degree that they would be considered working, even though they may be sitting at home. But they have an expectation that there's going to be a certain number of calls likely during the day, or they need to be able to get to the facility within a certain period of time, and that would be controlled. That would be considered hours worked. It would have to be compensated for the entire time, and it would have to be above the minimum wage, and of course it would impact the regular rate. So all very good questions. As you can see, there's many things here that can plague you. We hope that we provided you some information and insight into these various issues. And should there be questions that we haven't been able to get to, or should one strike you later in the day or later this week, feel free to reach out to either Aaron or myself for some clarification. We'd be happy to address whatever issues you have, and we thank you guys for your time today.
Thank you for joining us. This concludes today's webinar. In approximately 2 to 3 business days following the webinar, Epstein Becker Green will communicate the availability of the webinar recording and access to the PowerPoint materials. Thank you.